All right, so if you all will look up at the monitors, I'm gonna give you all some directions, and then we're gonna call the calendar. So this is the Spalding County State Court. My name is Josh Thacker. I'm your judge, and this is the probation and non-jury calendar. We intentionally started a few minutes late here because I wanted to make certain that everybody, there's a lot going on in this building, and I wanted to make sure everybody, frankly, went to the wrong place first and then got redirected to the right place. So if you're here today, it's because you're on the probation and non-jury calendar. I want to start out by saying that here in the Spalding County State Court, we believe that each and every one of you, as you interact with this court, deserve the respect and the dignity that you would wish for someone you care about. We'll extend that to each and every one of you as we interact with you all here today. Hey, please don't talk during court. Our goal is to move your case forward efficiently, return you back to your lives as quick as we can. I cannot do that if you're having sidebar conversations, and frankly, you're going to find real quick I don't have much patience with it. Nobody is virtual. All right, cell phones. So I just did this back in the back. Everybody take a moment, grab your cell phone, pull it out of your pocket and purse right now. Check it one more time and make absolutely certain it is off. If your phone rings after this, it means you ignored the instructions that I just gave you, which means I have to have a contempt hearing with you. I don't want to. I'd rather you just turn your phone off. All right, lots of movement out there. Thank you all very much. All right, this is the correct courtroom for you again. If you're on probation with the Spalding County State Court, and you're being supervised by the Spalding County Sentence Enforcement Team, or you have some other motion that you need me to hear today. Or a couple of you have I know one person has a bench warrant and they're walking in. That's a normal part for these Thursdays. This is not the correct courtroom for you if you received a citation from the City of Griffin Police Department and you're supposed to be next door in the City of Griffin Municipal Court. So if that is you, just show your paperwork to the bailiff and they'll get you moving in the right direction. And of course, there's Superior Court going on upstairs. Just make certain that that's not where you're supposed to be. So I finally put a picture in my slideshow. So here we go. Do you know who Janet Harmon Bragg is? So here's the deal. When you signed up to be supervised by the Spalding County Sentence Enforcement Team, you signed a piece of paper saying that you would park in the Janet Harmon Bragg parking lot, which is catty corner to it. Every single report day, I am flooded with complaints from the local businesses that my probationers are parking in their parking spots and keeping customers from having access to their buildings. I said for 6 months that I would have to ratchet things up if nobody listened to me and that you had to park in the parking lot. It's a huge parking lot and it's not a bad walkover, and it's usually a beautiful day here in Griffin, Georgia. No one paid attention to me. So here's the solution. And no one likes the solution but me. I'm the only one who likes it. So here it is. It's very simple. If you can't see that mural when you park your car to report for probation, then I'm going to issue a warrant for your arrest. It's just that simple. So if you cannot see that mural when you park your car to report to probation, then a warrant will follow you home and you'll be picked up and taken to the jail. I don't know how else to get everyone's attention. And guess what? Next time you report, you should turn to the person next to you in the lobby and you should ask them, hey, where did you park your car? You might want to go move it. My goal is for all of you to communicate with each other, take care of your tribe members, and keep them from going to jail. You can do that for them, and they would probably be very grateful. All right, calendar call procedure. I'm about to call the calendar. When you hear your name called, stand up. If you have an attorney, actually don't have any attorneys here. What you're going to do is if you're on probation and you're here for a probation matter, you just simply say probation and we're going to keep going. If you're here for something else, like a bench warrant walk-in or a license, if anybody's looking for a license permit or something else, some sort of motion, then you can just announce, give me quickly what else are we looking for on you, and we'll get that sorted out. Okay, so, all right, first item on the calendar, Jaden Allen. What is that?
Is that off, Marty?
That was off. I apologize.
Oh, that one's off? Wonderful.
Sorry, Judge, that was my fault.
Well, I was waiting for Director Matthews to say off.
I had her
I was 90% certain that one was off. So, all right. Montaya Allman.
That case is off, Judge.
Great. Wonderful news. Okay, and then I have a motion or something. Jalen Beck. Beck, okay, you're here.
Yes, Judge, that's Doc Upshaw's case.
Okay.
I spoke with Mr. Upshaw yesterday. He's filed a conflict in this matter. He has Fulton Superior Court this morning, followed by Fayette State Court, and then this court would be third in line.
Okay.
I think given the geographic distances he has to cover, and I checked, those are valid. Those two cases would take priority over this case, given the status of it. So I just told Mr. Upshaw I would announce to the court that where he is and he's got a valid conflict in, we would be ready to go otherwise on this. This is a motion to revoke.
Okay.
Mr. Beck has 3 cases pending in this court right now.
Let's do this. Let's give Mr. Upshaw about an hour. We never know where things go. After about an hour, what we'll do, or hour and a half. So sit tight. After about an hour and a half, when I take the first break, if we haven't heard from Mr. Upshaw, we'll pick a next date, and I'll have you sign a reset notice for that next date. So you're welcome, if you want, to step out in the hallway whenever, check in with Mr. Upshaw's office for an update. And if you get confirmation that he is not going to come, just tell the bailiffs, and they'll get us. We can get you out of here earlier than that. So, okay. Thank you, Mr. Beck. And I put a note here that Doc has a conflict. Okay. So Corey Barry. Barry. No.
Well, that's for probation warrant and tolling.
Granted.
Those are, it's a pretrial, and
Okay.
one of them did not get e-file, but it was properly served.
Okay. What was the case number on that one?
That one is 22 SR 1123.
Okay, so it was properly served, properly noticed, but just not filed.
Yes.
And she was ordered to be here on the other case, so I'm comfortable with that.
A bench warrant.
Mhm.
And just to let y'all know, I scanned it, you would know anyway, but I scanned the calendar, I'm not ready to do it.
Okay.
Marty, were both of those pretrials?
Yes, sir. Both of the pretrials both running concurrent.
All right, well, both of them are now bench warrants, and the pretrial is paused. Are these going to be in a position where once she's picked up, she can have a pathway to get them closed?
Both of them are eligible to terminate after 3 months, and she's already been on for 6. So yes, sir, she will have the ability to pay a monetary bond and be released.
Okay. That sounds great. Just want to make sure there was a pathway out. Okay, both warrants are signed. The pretrial intervention program is told, and we'll deal with Miss Berry when she gets picked up. On both cases. All right, Brandon Brown. Good. All right, thank you, Mr. Brown. And Mr. Brown, you're aware that you have 2 cases on the calendar today?
I wasn't aware of that.
Okay, we'll talk about that when you come up. Jontavius Bird.
Probation?
All right, thank you, Mr. Bird.
For the record, judge, it's a pretrial.
Oh, thank you for that. Mark that. All right, that's page 1. Reginald Collier.
That case is off, judge.
Wonderful. Robert Colquitt. Colquitt? No?
So I'm,
Oh, this is that guy that I said he needed to report back. So he may, will you see if he posted it?
I'll double check. As of yesterday, he had not.
Well, I ordered him to be here today to post his cash bond. So if he didn't appear, then I'm going to issue a bench warrant and I'm going to set a cash bond, and then he can just post it at the jail. Like, I was trying to give him the courtesy of a walk-in.
Yeah.
Um,
so you ordered him, I guess I missed that part last week. But you
he
ordered-
had chaos,
Yeah, he had
and
the
I
third
decided
case.
I was bringing order to his chaos. And so I don't remember what I did with the others, but this was the only thing outstanding. And so I said, I'm not going to let you just do this next round with that case. You are to either post a cash bond with the clerk. You're not waiving your right to a jury trial. You're just posting a cash bond, so that if you don't show up, I can simply forfeit the cash bond and I'm done with you. And I don't have to do this again.
That's exactly what you told me.
That's, I don't remember what I did with the other cases, but I remember that emotional moment because I was like, I'm done.
The other case you placed on probation
Sorry.
for no early termination.
I'm sorry about that. So,
Speeding ticket.
well, that's why I didn't want this one to go to probation as well. That's what it was. I was trying to foreclose this one going, and I just remember being very frustrated.
Yeah, he was the problem child with Judge Esser.
That's it.
We had
This
to
is
go
all
down there.
coming back to me. I had to stop. I had to leave the bench because y'all had to go because he was about to come out, he didn't like Judge Essery's verdict. This is all coming back to me now. And then he was ugly back there and wouldn't sign anything, so I put him in handcuffs. Oh, this is, yeah, oh yeah, I feel very confident in what I did. So,
So the state will ask for a bench warrant issue?
granted. He paid it?
Oh, we did.
Okay. Did he ask for a trial when he paid it?
I don't know if you paid it, it wasn't.
Okay, then he paid it, did not ask for a trial, and closed his case. Because I told him if he could pay it and ask for a trial, and he could have it. And he paid it and did not ask for a trial, which means the case is closed.
Fine with
Good.
me.
Fine with me, and I don't have to put him on probation with y'all. So, I think, oh, I know what I did for y'all. I put him on 0 tolerance for the duration of probation. So that y'all didn't have to go through all the hoops, because we couldn't even get him to sign the paperwork here in the courtroom. So, okay. Well, then I'm gonna put that that is closed. You gotta really work hard for me to remember all these details about your life.
The motivating factor in all that is when you put it downstairs for a couple hours.
Yeah. So. All right, John Cook. John Cook. No response?
Is that probation?
It is.
All right, we'll ask for a probation warrant and tolling.
Granted. He had a jury trial. Sorry, it's really coming back to me now. He had a jury trial in December because he said that the jury trial was biased. And then he had a bench trial with Judge Essery, who found him guilty as well. And then he said Judge Essery was biased. And then I was dealing with him because he wouldn't sign anything, and he said I was biased.
You don't like me neither.
And he, yeah, and so this is really coming back to me. Why? Because that was such an unusual thing to tell me he had to post a cash bond.
If I remember correctly, he had like 20-something citations.
Hmm. Yeah, it was a substantial number of cases.
You just had signed a warrant at the beginning of April for a different probation case.
With him, yeah. So this is all starting to come back. Okay, Willie Hightower? I think that's a show cause
That's
hearing.
correct.
Okay, all right, Mr. Hightower, that's just a show cause hearing. We'll come back to you in just a minute.
I assume Mr. Dutton's off of that.
Yeah, I don't show that they're still in. Okay, next one is Candace Jarvis.
Probation.
All right, thank you. Looks like you got one of your items resolved. Good job. All right, Joel Jones. All right, thank you. Joan Martinez. That's a permit request. Joan Martinez. I'll recall that at the end. If they're not here, I'll deny it. Madison Ogletree.
That case is off, Judge.
Wonderful. Travante Oliver. All right, thank you. And that's a pretrial.
It has to be pretrial.
Got it. Got it. Aaliyah Reed.
I don't know to say probation or no.
Yes, I'm with you, and I understand your hesitation. It looks like to me you're asking me to modify your probation conditions. Is that correct?
The license, because I-
She is.
Okay, that's just a motion, and we're good. So grab a seat. We'll come back to you. Stephen Robbins. Robbins.
What is that, Mark? Probation. We'll ask for a probation warrant and tolling.
Granted.
Is that 30 for 30?
No, sir, it's a 12-month TOC.
Okay. Just remind everybody, we have an 85% success rate in our 30 for 30, but all 15% remaining have to come see us. Okay, warrant it is. Okay. Tracy Rogers. All right, you wanting your probation modified, is that correct? All right, sit tight, thank you. Joshua Stroud. Stroud?
So, Judge, it's a motion or a vote bond in my office file. It's based on new charges, serious new charges out of Henry County involving the same victim. Melinda Johnson is representing Mr. Stroud in this case. She has a valid entry in. Her office, not Ms. Johnson, but somebody from her office contacted my office earlier this week to say that she has medical leave. There's not a medical leave filed in this case. We haven't actually heard from Ms. Johnson, and I'm not sure I've ever actually met Ms. Johnson. These are serious charges out of Henry County. Ms. Johnson's office indicated they don't even know where Mr. Stroud is.
I'm also going to gently point out that that does not release the defendant.
That was where I'm going with this. So because of generally I'm very willing to work with attorneys, especially when they've got medical issues, but because of the nature of this case, we'd ask that you issue a bench warrant for Mr. Stroud.
Okay.
So if he is contacted by law enforcement, he'll be held, and then we can sort all this out.
Yes.
I got a victim who's been victimized at least twice by Mr. Stroud now.
Right, and I'm willing to grant that, and my reason I'm willing to grant it is that ungranted, whoever's yawning audibly, it's pretty disrespectful. Don't do it again or step out of the courtroom. All right, so as far as Stroud goes, I'm issuing the warrant for my purposes because he was ordered to be here and he's not here. Conflicts and ungranted leaves do not release the defendant. And I would have absolutely done the same thing with Mr. Beck if he was not here. So, and we will sort it out when he gets picked up and when Johnson gets back from medical leave. So we're a pretty responsive court. I'm not at all worried about him being stuck out in the jail, lost, when he gets picked up. Okay, that warrant is issued. So, and then DeQuavia Sullivan, looks like they're asking to modify. Sullivan's asking to modify. No,
Is he here?
I'm not seeing a response.
We'd ask that motion be denied for lack of prosecution.
Okay. Got it.
The state was opposing that anyway.
Okay. All right. Well, that's denied for lack of prosecution. And I bumped into it and I wish I grabbed it. There's some sort of statute that says what the time frame is until they can file again. I'm just going to say 4 months. That sounds about right. There's something that says they can't immediately refile when it's. Okay, so I'm not too far. So, okay, so I'm going to put leave to refile in 120 days. Okay, I just didn't want him showing up tomorrow and refiling it because he didn't come to court today. So, okay, then we're in good shape. Mr. Shepard, what all are you here on?
Mr. Beck's case, which I think is very doubtful that will go this morning.
Okay.
Assuming that it doesn't go this morning, can we reset? I guess we've got what's our options, the 9th and the 16th? Is that what's
I left my master calendar on my desk.
9th and 16th, yeah.
Okay, so
Marty, what's next week look like? Nothing?
okay. Oh, perfect. The 9th would be great then. So,
We don't have it at 9?
well, she doesn't have anything
don't have
on it.
Okay.
It's still officially there, but it'll end up being
We'll have to just tell you what we're doing.
Okay.
Yeah.
We're just not using all of them because they were so little, so.
Fair enough. All right. Then,
your call.
Is
9th
there
is-
anything on the 9th, Erica?
There's one case.
Okay, but if we gotta get dressed up, we'll just put this on
Yeah,
tonight.
I'll be there. Mr. Beck, I'm gonna go ahead and make the call. You're gonna step out into the hallway, wait for the bailiffs. Do not leave until the bailiffs come give you your next set of instructions, okay? And whatever you sign, you take a copy to Mr. Upshaw, okay?
Yeah, she was just telling me how she just contacted him.
Yeah.
He sent her a text in and he would not be able to make it.
Perfect, that's the information we need, so. This is why we have good relationships.
And I
So,
have there's an email from Doc.
I don't know who's talking. You're talking. Why are you talking? I'm trying to hold court up here. And as I said at the beginning, I've got a lot of things I'm trying to do, and conversations out in the gallery will not be tolerated. So you, sir, need to step out into the hallway, please. So that means stand up and walk out of the courtroom. And pull your pants above your butt.
Good God.
What is your name?
Shannon,
What is your full name?
Dr. Shannon.
Great. Sit out in the hallway.
Pre-trial.
That's Mr. Malloy's case that he was here on. I started
Okay.
before that pre-trial offer this morning, but I was dishonored it because I told him.
Well, Terrence already left. We'll just leave him out there for a while. All right, what else you got?
Okay, let's see, that was back. Then we've got these couple of, motions to modify probation.
Do you have a preference in, like, walking through what's easiest for you? Because you'll end up involved in both sets, and I'm going to do both in a group. I'm either going to do the walk-ins first or deal with theirs and get them out of here. Okay, let's deal with what you have, Mr. Shepherd, because that's all you have, and then you're out the door. And then the walk-ins, y'all who are waiting for walk-ins, don't panic. They go very fast. So let's do the things that you have, Mr. Shepherd. So I'm actually going to swear her in, and then I'm actually going to give you the floor and let you recommend to me which things you'd like me to call next. So Director Matthews, raise your right hand. Do you swear in all testimony you will give today in all matters that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, I will not swear you again. You're sworn in on all matters. Mr. Shepherd, if you will call the items that you are here on that we can resolve, and then I can get your team out of here.
Sure. All right, thank you, Judge. Let's do Ms. Reed, Aaliyah Reed.
Ms. Reed, if you'll come on up, please. And Ms. Reed, you are welcome to either stand at the podium if you wish, or you may sit at that first seat and use that microphone. It is completely your decision. I do not have a preference. Just wherever you go, make sure you use that mic.
Okay.
All right. I'm going to have you raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Take your hand down and state your full name for me.
Huh?
What is your full name?
Aaliyah Reed.
All right. And Ms. Reed, you're here today because you've asked the court to modify your probation conditions. So you're not in trouble. Your worst case scenario is that I leave things as they are. Your best case scenario is I grant you what you want. So if I give you what you want, what would I do today? What is it you want me to do today?
Just lift me getting my license because I don't know how to drive.
Okay. All right. Mr. Shepherd, do you have anything you want me to?
Judge, I mean, ordinarily, that's a provision that's waived if the defendant cannot get their license for some reason. I think this is the first one we ever had where somebody just said they just didn't want to. But if Ms. Reed is telling the court under oath that she does not intend to drive, has never drove, does not know how to drive, and has no intention of getting a driver's license, I think this is the only thing that would be keeping her from going to non-report status on her case. From what I'm aware of, she's done everything else she's been asked to do.
So you don't currently have a license?
No, sir.
What if I simply just converted it to surrender license and put her on non-report?
That's fine with me.
That would achieve the same result. You would not have to take any action. You would get what you need, which is either a confirmation that she's not driving or that she's going to get a license, and then you can put her in non-report. Am I missing?
I mean, I'm fine.
She has a non-report option. She's eligible to go to non-report today. That's the only thing.
Yeah, if you just waive it, I'm fine with just waiving it.
Oh, you're fine with waiving it?
Yeah,
Okay.
I don't have any objection.
He's kinder than me today, so good. That'll work.
You're not gonna drive, you're not gonna drive.
You're not going to drive, right? All right. I've got you under oath telling me you're not going to drive.
I'm not.
I'll drive her in that case.
Okay. Assuming that you've satisfied all the other options with all the other obligations, which I think they're telling me you have, they'll review it and make sure. Do you need her to report? Okay, then they're very confident you're good. So you are good to go. You're in non-report probation. So,
Okay.
so as you don't have a license, if you are caught driving, it will be an arrestable offense, and we will find out. I know you won't do that, but it's my job to say awkward things like that out loud.
Okay.
So, okay. Do you have any questions for me?
No, sir.
All right. Thank you very much. You are free to go.
Okay. Thank y'all.
If you want to get a copy of the order later, you can check in with the clerk. But I won't probably sign it till this afternoon. Okay. Thank you, Mr. Shepherd.
Yeah, she's done everything else she's been asked to do, so.
Sounds great to me.
Next one would be Ms. Tracy Rogers.
All right. Ms. Rogers, if you'll please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, take your hand down, state your full name for me.
Tracy Rogers.
All right, Ms. Rogers, you are here today because you have requested that I change your conditions of probation for the better. If I do what you want me to do today, what would I do?
I would like early termination.
Okay, Mr. Shepherd?
Yeah, this one's just a little bit different. This was a cruelty to animals case. It was either a sheep or a goat. I don't remember exactly. I know it was in terrible condition. It ended up dying as a result of the neglect. One of the special conditions on this case is that the defendant shall not possess any domestic animals. Because of that special condition, she's already on non-report. Because of that special condition, the state has opposed to an early termination on this because just with the nature of the charges, what she was convicted of. I don't think that an early termination is appropriate because I don't want her having any control over any animals.
How much time is left?
Her cases will terminate on October 23rd.
Okay. So tell me, Ms. Rogers, why is it, if you're already in non-report status, is that correct?
Mm-hmm.
Tell me why you need me to convert it from non-report to terminate.
I was under the impression that I can do an early termination if I did community service and paid all my fines and fees.
Okay.
That I could request that.
Yes, you can request it. Your request
Yeah.
is fine. I'm just trying to decide whether or not to grant it. So
Okay.
you're properly here.
Okay.
And you're doing exactly what you're supposed to do to ask. Let me look at something really quick. But she is on non-report. She's done.
Yes, so she had an option to go to non-report after 3 active months of probation.
Okay. All right, Ms. Rogers, anything else you want to know?
No,
Is your birth year 86 or 77?
it's 86.
Okay. Okay.
And just for the court, she's been in non-report since April the 16th.
Okay. Ms. Rogers, I have my case here. Which was from 5/24 of 22. So May 24th of 2022, so 2 years ago. But I'm seeing that since that date, you've received, looks like a set of new animal ordinance violations, much more minor than what we have, but you still received those. What I was looking for was a blank space under following charges. And I'm not seeing a blank space. I'm seeing 3 new ordinances that were before this case started. So it's not like sorry, I just saw Mr. Shepherd's face. It's not like there should have been a revocation, but I'm also seeing the fact that these things were not, and these were pleas. So no, I'm not willing, because you have new ordinance charges that lined up where it wouldn't have been a revocation. It's still not enough for me to feel comfortable changing the terms that were negotiated.
I understand.
And so that's a reasonable question, but that's a no for me. So I'm going to put that is denied. You still on non-report. Just don't possess any animals or catch new charges, and you'll never know that I'm here. So, but I'm also obligated to tell you that if you do either of those things, you'll very quickly know that I'm here because I'll issue a warrant and hold you without bond. And I'm sure you won't, but as you heard me say a moment ago, it is my job to say awkward things like that out loud. So, okay. Good luck to you, Ms. Rogers.
Thank you.
Okay.
I believe that's it. The other one that I looked at was Mr. Sullivan, but he no-showed this morning. So that
Yes.
was off.
So he's
Need
a,
to go anything?
so he's a,
Not in the sugar, it's just in a pre-trial.
That's what everyone did.
how about if we bump into the pretrials, we'll just one of y'all step
I'm
out
not far
now.
away.
So, okay.
Your Honor, I was just informed that the gentleman that sitting in the hallway is left.
He left?
Well, he's,
I haven't had a chance to meet with him.
Hey, Piper, he's a warrant, so,
Yeah, that's the best.
I haven't signed lift the warrant, so if you want a radio for somebody to go put him in handcuffs and put him in the holding cell.
I absolutely will.
And that's Mr. Shannon.
Shannon.
Thank you.
That was fixing me a $250 pay and go free trial.
Valkyrie Shannon, 22 SR 0913.
May I have that case number again?
22 SR 0913.
I believe my instructions were to step out into the hallway. Okay, well, if he's not in that hallway, then y'all are to take him into custody.
Yeah, so if we take a break, I'm gonna go see if I can find him.
Okay. All right, and do y'all mind letting Terrence know that it went sideways? That, you know, he wasn't there to supervise me and I went off the rails. Okay. Anybody need a break before we step into the next round? Okay, well, let's keep moving then. You ready to do the walk-ins? All right, so I'm going to step into the walk-in hearings. As I told you all, these go a whole lot faster. So what I'm going to do is I'm going to call you up to the podium. I'm going to place you under oath. I'm going to go through a couple of very basic questions with you, and then I'm going to have Director Matthews do two things. She's going to read off what the allegations are as to how you're being alleged to not be in compliance with your probation, and then she's going to read off what the state's recommendation is as to how the court should respond on your case. I reviewed those recommendations. And then I'll ask you two questions. A, do you admit to the violations? And B, is that recommendation acceptable? If either of those are no, we'll move in some new directions that we'll talk through at that time. If the answers are yes, then I'll make certain that that recommendation is proper, and I will very likely grant it. So with that said, let's start with Brandon Brown. All right, Mr. Brown, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Brandon Thomas Brown.
Mr. Brown, you're here on two cases. I think you were the one who indicated you were not certain of that initially. Your cases are 22 SR 1572. It is a suspended license charge. And then you also have 23 TK 1630, which is also a suspended license charge. And there are allegations, individual allegations on each of these of you being out of compliance with your probation. Do you understand what you're doing here today? The
Yes,
question
sir.
that I'm here to answer.
Yes, sir.
All right. You have the right to have an attorney and you're here representing yourself. Is that what you want to do?
I didn't know if I was supposed to have an attorney or not.
No, you don't have to have an attorney. It's just that you have the right to hire one if you wish.
I would like one.
So, all right, well, let's review. So here's how this works. So now, so this isn't like a jury trial where when you ask for one, you get one.
Right.
With a probation matter, I now need to review the allegations. If the allegations are technical, then I have the right to just say, we're going to go on forward. If the allegations involve any sort of, complex or difficult or new charges, or like scientific testing, then I would then find that there is a need to move your case along. So give me just a second.
Okay.
Okay, in 23 TK 1630, the allegation is that you got behind on your fines and fees and did not use community service work fully to get caught up. That is a simple technical. The second one is that you failed to complete your community service work as directed. That's also a simple technical. Moving over to 22 SR 1572, it's that you failed to pay your fines and fees or use community service work to get caught up. Director Matthews, I do not show any additional violation allegations. Is that correct?
Not as of the date that the petitions were drafted.
Okay. Mr. Brown, I'm going to find that those are simple technical violations, and I'm going to go ahead and move forward with the hearing.
Yes, sir.
And so these are matters that I think are within the ability of the court and of you to sort out, and we're going to move forward. So, all right, floor's yours.
Judge, on 23 TK 1630, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendants failed to pay the court fine and fees as ordered or utilize community service work in lieu of the court fine, being in arrears $379.88. The defendants failed to complete court-ordered community service at a rate of 6 hours per week. On 22 SR 1572, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendants failed to pay the court fine and fees as ordered or utilize community service work in lieu of the court fine, being in arrears $330. The recommendation on the first case that has the court-ordered community service is for him to report as directed payments of $110 biweekly, the court-ordered community service at a rate of 8 hours per week, 0 tolerance for 90 days. His next report date would be in person on May 8th between the hours of 1 and 5. On the second case, it would be report as directed to convert the fine to 74 hours of community service at a rate of 6 hours per week. That would begin on June 1st. 0 tolerance for 90 days. The next report date would be in person on May 8th between the hours of 1 and 5.
All right, so 2 questions. Number one, on this set of violations across both of your cases, do you admit or deny the violations?
I admit him.
All right, and is that recommendation acceptable to you
Yes, sir.
to get you the nudge that you need to get back on track?
Yes, sir.
All right, well, given your admission and given your request of the court to accept the recommendation, I've already reviewed everybody's recommendations. I'm going to accept those recommendations.
sir.
And I'm going to make them the order of the court. I think they give you the nudge that you need to get your cases back on track, and frankly, moving towards full compliance. Yeah, I agree. All right, so any questions before we part ways?
No, sir.
All right, so if you will head back that way, go out into the hallway, have a seat out in the hallway. Don't do what Mr. Shannon did.
Yes, sir.
Just sit out there, wait for the bailiffs. They're going to bring you your paperwork. They're going to have you sign it, and then they're going to give you copies before you leave.
Yes, sir.
Okay? So, Ed, what we do is Marty's. To give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
John Tavius Bird.
All right. Mr. Bird, you were here today on 22 SR 1048 because your sentence enforcement supervisor, you're participating in our pretrial intervention program, and your your sentence enforcement supervisor has filed paperwork with me alleging that you're out of compliance with your pretrial agreement. Have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yeah.
You ready to go forward?
Yeah.
All right, go ahead.
Judge, on 22 SR 1048, the defendant is alleged to have violated the terms and conditions of the pretrial program in the following. The defendant failed to report to probation as directed, having missed 4 of 6 scheduled appointments. The defendant failed to pay the court fees as ordered or request a waiver, having never made a payment. The defendant failed to complete community service hours as directed at a rate of 6 hours per week. Judge, it would be our recommendation that we don't feel that Mr. Bird is a candidate for the pretrial intervention program due to no reporting, no payments, no compliance with any condition of this case. I have provided a recommendation to the court if you want to review his case in more details. He alleges that there's a medical situation. We've asked for documentation on February 13th and on April 11th, and we have not received anything to assist Mr. Bird with his case.
Okay. So so let's talk a couple of procedural options. If I remove him today, Are there any other cases, consecutive, concurrent, anything else? All right, so it's just this one. And if I, if I do remove him, what I think I'll do is, well, I would need to make a decision on the bond. Or I could bring him back. Well, you won't be here next week. So
I plan to come up or still.
You are?
In case you walk in and things like that. We're just not scheduling hearings.
okay, because what I was thinking I could do is remove him from the program. I'm just talking procedure. I haven't made a decision yet. I could remove him from the program. I could order him to come back next Thursday because he's represented. If I'm going to move him back in there, it needs to be through the public defender's office. And I can, instead of dealing with the bond today, I could just have him come back next Thursday for a bond revocation hearing, and then go from there. Okay, Mr. Byrd, that also give him time to go get, I really wanted to go get the medical paperwork. So, Mr. Byrd, do you understand the issues that they're having is that you're saying that you have a medical condition?
Yes, sir.
And that is perfectly acceptable to us. We work with people with medical conditions all the time, but we don't take anybody's word for it.
Right.
Everybody who says they have a medical condition must provide supporting paperwork, and they're saying they don't have it.
Yeah, no one told me about the paperwork that I needed.
So you're saying no one from the Sentence Enforcement Office ever asked you for medical documentation for your medical issues?
Yes, sir.
Okay. Well, then let's just back this up a little bit. Do you admit or deny that you failed to report to 4 out of 6 scheduled appointments?
I admit.
Okay. Do you admit or deny that you paid 0 on your fines and fees, and that you did not make any requests for any sort of waiver or modification?
I admit.
Okay. And have you completed any community service work?
I haven't.
Okay, well then those are admissions on all 3. I find that the allegation that the Sentence Enforcement Office never once requested medical documentation to be meritless, as it's part of the standard operating procedure of the department. Okay, having admitted all of these, here's what we're going to do. I'm going to find that there is a sufficient, with the admissions, it's sufficient for me to find that you are not a candidate for the pretrial intervention program. And I'm going to remove you from it. What I normally do at this point is pivot directly into a bond revocation hearing, because completing this program was a condition of your bond.
Yeah.
So here's what we're going to do. I'm going to have you sign a reset notice for next Thursday. You're going to take that notice to the public defender's office, because I'm pulling them back into your case. And it's for a bond revocation hearing. Where there's no witnesses needed. I just need to decide what I'm going to do. And on that day, I'm going to have your bond revocation hearing. If you want to bring some paperwork from your doctor, and I can tell you right now, you can bring a stack of paperwork that thick, but it won't do you much good if we've got to pick through it. I'd rather have a 1-page letter from your doctor saying, these are the conditions, these are the symptoms, these are the limitations.
Gotcha.
So if you want to go get that and give it to your public defender, you can do that.
Okay.
But let me make this very clear. There's a pretty good chance that you're going to go to jail at the end of the hearing on Thursday, because I've already found that you violated your bond. But at the same time, I want them here because they will know the other options to explore to try to have you not go to the jail. So if you don't go see them and you come back here and you haven't let them know, the public defender's office, then I'm going to shrug my shoulders and go, well, that's your call.
Yes, sir.
All right. Are you going to go see them today?
I have dialysis at 11. I get out at 3. If they're still open, I can.
Okay. Well, I strongly suggest you do that, because the jail does have the ability to provide people with dialysis.
Okay.
And I just want to make certain you understand that your medical condition will not factor into my decision of whether or not you need to go to the jail. So, do you understand that?
Yes, sir.
But I've already told you the other things you can do that I strongly suggest that you do. Okay?
All right.
All right. He's going to need to sign that and a reset notice for next Thursday. If you'll head back that way, ever since that idiot jumped over the bench in Vegas, they want me to send everybody that way. All right, so that was a partial decision. So the partial decision was removed from PTI, reset to May 9th for bond revocation hearing. Okay. All right, that'll take care of that.
Willie Hightower?
Do you mind letting Chastity know about that so they can reach out to the solicitor's office? All right, please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Willie Hightower.
All right, Mr. Hightower, you are here today. I think you're my show cause hearing. Yes, great. So you're so there's no allegations that you're in trouble or anything else. What today's hearing is about is my sentence extends out into the future.
Yes, sir.
And I'm required to have what's called a show cause hearing for me to decide whether or not to continue your sentence the way it was originally ordered, or whether or not I want to modify it to bring it back in. And by law, I'm required to have this hearing, or frankly, make this decision.
Yes, sir.
So do you understand the kind of the purpose of today's hearing?
Yes, sir.
Your worst case scenario is nothing changes.
Yes, sir.
Okay. Do you have, Mr. Hightower, do you have a preference as to whether or not you continue on your probation, or whether or not you are wanting your case to close?
I prefer closing, Your Honor.
Okay, that's fine. I just need to put that on the record. I assumed
Yes, sir.
that's what you wanted. All right, Director Matthews, the floor is yours.
All right, Judge, this case is a 36-month case, has a non-report option after 12 months. He is on for DUI, reckless driving, failure to maintain lane, and driving with an open container. He has been on active probation for 735 days. He was court ordered to complete 40 hours of community service. He has completed that. He was court ordered to obtain his license. He's completed that. He was court ordered to complete DUI school. He has completed that condition. He was court ordered to complete a substance abuse evaluation. And then from a violation, he had to complete a second substance abuse evaluation. Both of those have been completed. Random drug screens, 8 days in jail. He did have one consent in January, on January 5th of 2023 for a positive drug screen for alcohol. He'll be eligible for non-report on May the 15th, as long as the drug screen he took on Tuesday comes back clean, and a payment of $21.
Okay, so that's just 2 weeks from now?
Roughly, yes, sir.
Okay. Yes.
Ms. Matthew, I made a payment for that drug screen.
Okay, I did not check. So
Okay.
Tuesday.
Okay. Well, Mr. Hightower, it sounds like you had some bumps along the road, but that you've put a substantial amount of effort into getting your case back
Yes,
on
sir.
track. And we love those kind of stories. We don't expect perfect probationers. We just expect
sir.
folks who continually try to work to fix their mess. So, so here's what we're going to do. It sounds to me like you're literally within striking distance of getting your case to non-report status.
Yes, sir.
And so I think the best course of action is just to let that play out, because it's only 2 weeks from now. It's not going to cause like he's not going to roll over to like a new month or.
No, sir.
Okay, so that was my other thing, is I didn't want to push it out the 2 weeks if it was going to cause more money to be added to your case.
Okay.
And Director Matthews is telling me that between now and the 2 weeks when you would qualify, no additional monies will be added to your, because of the monthly supervision fee and all that. So, okay, so the short answer is that I'm going to put that your case shall continue as originally ordered, but that's only because within 2 weeks, you're going to go to non-report, and you'll be able to put me in your rearview mirror.
Okay.
So, so good job on that. And although you didn't get what you wanted at this hearing, oh, he doesn't need to sign that, does he?
He doesn't. Can we give him a copy?
Yes. Do you have any questions for me?
No, sir.
Okay. Hey, good job getting your case back on track.
All right, appreciate it.
So, and if you'll head back that way, they'll also give you a copy of your order before you leave. Yeah. All right, we've been at this for an hour. Let's just take a quick 10-minute break for the bathroom. As soon as everybody's finished, get back. We should easily finish up here by 10:30. So, all right, quick break, everybody, and then we'll back in 10 minutes. All right, let's jump back in. You may call the next case.
Joel Jones.
Yes,
Ms. Jones, raise your right hand for me. You solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
yes, sir.
All right, take your hand down, state your full name for me.
Joel Bryant Jones.
Mr. Jones, you're here today because your sentence enforcement supervisor has filed paperwork with the court alleging that you're out of compliance with your probation. You understand what you're doing here today?
Yes,
You understand that you have the right to have an attorney represent you?
yes,
And you're here representing yourself. Is that okay with you?
yes,
Okay. Ready to go forward?
yes.
All right, go ahead.
Judge, on 22 SR 1145, the defendant is alleged to have violated the terms and conditions of probation following. The defendants failed to follow the recommendation of the substance abuse evaluation of entering a court-approved treatment program. So, Judge, may I give a little commentary?
Yes.
Okay. So he did a substance abuse evaluation with Mr. Jerry Daniel, and I brought that for the court today. Mr. Daniel recommended for him to go and be medically supervised detox due to a risk of withdrawal, and then to follow that up by long-term residential treatment. I have, Mr. Jones has spoken with Ms. Rich extensively that he has no interest to go to residential treatment. He has since tested clean, and so I personally reached out to Mr. Daniel, had a long conversation in reference to Mr. Jones this week. And Mr. Daniel is willing, and I have an email proof as well, to abbreviate the recommendation that he provided. His goal is for Mr. Jones to have long-term sobriety in the whole matter. So he's willing, if the court's willing, to allow for Mr. Jones to report as directed, to start going to at least one AA or NA meeting per week, to continue to make his payments of $261 a month, to be drug screened at least twice a month randomly. His court-ordered DUI school would be due by his extended deadline of October the 23rd. He'd be on zero tolerance for 365 days. His next report date would be in person on May 8th between the hours of 1 and 5.
Okay. I was not with you until you said 365 days of zero tolerance, and then I was. So the short answer to that is yes. That's acceptable to me because I feel like it gives you freedom on this side and it gives me guardrails on this side, because if you don't do it, I'm just going to jump straight to a warrant.
I have lack of transportation.
So, well, this gives you space to try. You got to do some. I need you to do something.
I've been depending on my sister, and her truck's in the shop. The transmission went out. I walked to court today.
Well, this gives you until October to get your deadline sorted out.
But we're taking away the treatment.
You understand that?
Not really.
Well, I can order right now that you be taken into custody and that you wait until a bed comes open at a treatment facility. You understand? That's an option. Piper walks over, he put handcuffs on you, I hold you in the jail until a treatment center is open, and then you go straight from the jail to that treatment center, and I order you to stay there a year. That's what the recommendation was. Do you understand? That is a very real scenario of what could happen in about 3 minutes.
That sounds awful.
I know it sounds awful. Because of the work you've done and the communication you've had, they are rolling that recommendation back a little bit to make it easier for you given your life situation.
Right.
Okay, you can follow that. I'm going to follow the recommendation. Okay, that's the difference. So they've come up with a better solution that fits your life better.
I hope so.
And if it doesn't, if you don't do what you're supposed to do at this point, I will feel very comfortable issuing a warrant for your arrest because we've rolled it back to meet you. Okay? All right. Any questions for me?
None I can think of.
Okay. Good job.
Like I say, I lack of transportation. I can't get no one to help me.
And again, all of your deadlines are extended out to give you time to figure that out. Okay?
Yes, sir.
We deal with all kinds of folks in all kinds of situations, and you know, a lot of people don't have transportation, and you got to sort that out. And this will give you time to do that.
Like I say, I walked to court today. But it took me about a little over an hour.
Yeah, and we're gonna give you room for that. All right, Mr. Jones, you may step out that way into the hallway. Wait for the bailiffs. Do not leave until they come out and talk to you.
Do I get a paper?
So yes, you're gonna sign it out in the hallway.
Just step out in the hallway.
Just put him in cuffs. He's still going to jail. Erica, go ahead and add him to this guy. He's about to come in to next Wednesday's count.
Take your hat off there, please.
Wow. Step up to the left there.
All right, Piper, put cuffs on. No, we can go to the front as long as you don't have these. Why don't you leave?
I just went out to have a smoke.
Go sit down in the jury box. I'll talk to you
I'll
later.
be in a minute.
Yes, sir.
Okay, find these.
Javante Oliver.
Good morning.
Good morning.
If you please raise your right hand for me, do you solemnly swear or affirm the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, take your hand down and state your full name for me.
Trevante Oliver.
All right. Mr. Oliver, you're here today on 22 SR 1647 because your sentence enforcement supervisor, you're participating in our pretrial intervention program, and your sentence enforcement supervisor has filed paperwork alleging that you're out of compliance with your contract. Do you understand what you're doing here today?
Yes.
You have the right to have an attorney represent you, and you're here representing yourself. Is that what you want to do?
Yes.
Okay. All right, that was a shrug and a hands out and a no shake of the head and then a yes. I just have to acknowledge that there was a little bit of nonverbal mixed in there.
Because I didn't know that I was supposed to have an attorney to come or anything like that.
So you don't have to have an attorney. You just have the option to have an attorney. Because there's no jail time on the table today, you would not qualify for the public defender for this hearing. It's just that you would have, if you walked in the door with a private attorney, you would have had the right to have them here to represent you.
Okay.
Does that answer your question?
Yes.
Okay. And again, these are very simple allegations, which is a reporting allegation and a fine and fee allegation. So, so you would not qualify for the public defender based off of those allegations.
All right.
Does that answer your question? I know it's not the answer you want, but does it answer it?
Yeah, you answered.
All right. You ready to go forward?
Yes.
All right, go ahead.
Judge, on 22 SR 1647, the defendant is alleged to have violated the terms and conditions of the pretrial program. The defendant failed to report to probation as directed, having never reported. The defendant failed to pay the court fines and fees or utilize community service work in lieu of the court fine, having never made a payment. Judge, it's based off our recommendation that Mr. Oliver is not a candidate for the pretrial diversion program. There is an alternate recommendation there for you to review.
Okay. Why did you never report? I'm sorry, I got ahead of myself. I just assumed that was true. Is that true that you never reported?
I tried to report online because they set me up for due online, but I called my probation officer and told her that like every time you give me like a little numbers to put in to report online, it never goes through. So then she told me to report come in person, but I got the days mixed up. I was supposed to go on the 3rd, but I ended up going on the 4th.
Okay.
And I text her about that too also as well. Then now I'm here today.
Okay.
And the reason I can't pay because I thought that my charge was going to be dropped and I just pay fines, but I still have a pending charge. So I drive a truck, so I can't really can't get no job because I still have pending charges.
Okay. Did you ever end up reporting in person? Like you were on a time when you were supposed to be there?
That was only one time, but it was supposed to be on the 3rd, but I went on the 4th because I thought it was the 4th. I read it wrong.
Okay.
I read the 4th of the month instead of the 3rd of the month.
And this went on from January through April?
No, this was in February.
Okay.
I think I got started.
So February through April?
Yeah.
All right. Okay. Anything else you want me to know, Mr. Oliver?
That's really all.
Okay. Well, Mr. Oliver, it wasn't quite an admission, but I'm going to take it as one because the testimony he gave was that he was having difficulty reporting online. His case did start in January, and his online reporting was unsuccessful in February and March. And then he was given an in-person report in April, and he didn't report on that. But I also do need to note that the Sentence Enforcement Office is open outside of those hours, so he could have walked in pretty much on any business day during business hours to get this resolved, and I'm going to say he chose not to. So, here's what I'm going to do. I'm going to do the same thing with this one that I did with the last one. So for next Thursday. So Mr. Oliver, I'm going to go ahead and sign an order saying that you're not a candidate for the pretrial diversion. And then what I'm going to do is next Thursday, we're going to have a hearing on whether or not I'm going to revoke your bond. Because your bond, part of your bond requirements were to complete these conditions. And so I just want to point out that you can and should fill out an application with the Public Defender's Office if you want them to represent you. I don't show that they currently are. Oh, no, you have Mr. Diamond. Well, you can bring Mr. Diamond back if you want, or you can fill out an application with the Public Defender's Office, or you can represent yourself. I have no preference. But Mr. Diamond, your case is kind of starting to come back to me. Mr. Diamond worked very hard to get you into the pretrial diversion program, and I know him very well. And I don't think he's going to be at all pleased that you did nothing to stay into it, because you did nothing as you were supposed to. So, okay, do you understand our next steps? So I've removed you from the pretrial diversion. You're going to come back next Thursday. And next Thursday, we're going to have a hearing about whether or not I'm going to revoke your bond or not. And again, Mr. Diamond still represents you technically. So you need to work that out with him, okay? But either way, you have to be here next Thursday. Do you understand that? Okay. All right. Step back that way, step out in the hallway, wait for the bailiffs out there. You can call your next case.
Candace Jarvis.
Okay. That doesn't mean it's supposed to be there. Oh, okay. All right, raise your right hand for me. Do you solemnly swear or affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, take your hand down, state your full name for me.
Candace Danielle Jarvis.
All right, Ms. Jarvis, you are here today on 21 SR 2289, from where you are on probation with the Spalding County State Court, and your sentence enforcement supervisor has filed paperwork alleging that you are out of compliance with your probation. Do you understand that's the question on the table today?
Yes, sir.
You have the right to have an attorney, and you're here representing yourself. Is that what you want to do?
Yes, sir.
And you ready to go forward?
Yes, sir.
All right. And sir, if you're standing with her, raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter will be you may give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And state your name.
Robert Allen Pugh.
All right. Spell the last name for me?
P-U-G-H.
Okay. All right. That's just in case you speak. All right. Ms. Jarvis, any questions?
No, sir.
All right. You ready?
Yes, sir. Judge, on 21 SR 2289, the defendant is alleged to be have violated the terms and conditions of probation in the following. The defendants failed to pay the court fine and fees as ordered or utilize community service work in lieu of the court fine, being in arrears $1,536. Allegation B, the DUI school has been turned in prior to today. May I give commentary?
Yes. Oh, yes.
So Judge, Ms. Jarvis is currently on felony probation. I've spoken with her several times in lieu when I was training other officers. And I do feel that she's working very hard to try to get her life back on track. She's got her back against the wall when she was actively addicted. We have randomly screened her. She has not been positive. She's entered into the fatherhood program, so she's trying to work that. Felony probation is in compliance. Judge, this case only has 45 days on it. I did want her to get the DUI school and things that I was not willing to ask the court to suspend those conditions. But I am willing to ask, because of her compliance and because she's on felony probation, if the court would be willing to suspend the court fine and allow her to remain on probation. She does have a consecutive case that's 12 months with no early termination that would begin in 45 days.
All right, help me understand the overlap between us and Superior Court or the felony probation.
I'm not quite sure how many years she's got on it, but she's recently
It should
started.
be another year. I'm in phase 2.
All right, and that would line up with us because we would have another year
Yes,
as
sir. And
well.
while they're in phase 1, I'm not sure if you're aware, but they can't work because they have so many conditions and time constraints. So it's really hard financially. But our community service, it did take her an extended amount of time to get that done, but she has community service at felony as well. So I didn't really offer that.
Yes.
So my options I felt were a little bit more limited for Ms. Jarvis, but I don't feel like she's willfully not trying to take care of her case.
Oh, no, if you're participating in that program in Superior Court, you have a full plate.
I'm
So,
grateful for the program.
Okay, I'm okay with suspending them because that way, if something happens, I can always reinstate them. So I'm willing to suspend them, but I'm gonna place on there that they will roll over to the next case. So they will remain suspended, but they will be sitting in the next case.
Yes, sir.
So in other words, if you do what you're supposed to do, you'll never see them. If you don't do what you're supposed to do, I'm gonna pull them back out and put them back on the table and say, this is here as well. So that way I'm not giving them up 45 days from now.
And if I may, just to add to the thing, she is trying to get a job. She's gone to Southern Crescent Technical and got a job, went to the job fair, everything. She's doing what she's supposed to do. I work alongside with her as a forensic care mentor. She's doing great in the DRC, and we all know how the DRC can be. It's intensive.
Yes.
So, yeah, she's doing wonderful.
Well, and I'll go ahead and tell you that part of, being involved in the day reporting center is something that I'm always appreciative of in the court because I've been doing this for a couple decades now. And I was a prosecutor and I sent people to the day reporting center back when it was called the GRIP. And then I, as a defense attorney, put folks in it, and I'm very well aware of the intensive nature of it and frankly, the success rate from it. And so I agree with Director Matthews that whenever we've got someone involved in I still call it the GRIP. Whenever we've got somebody involved in the DRC, the day reporting center, I want us to kind of move back a step when we can because it's such a good program. And I don't want them to forget we're here, but at the same time, I don't want to interrupt that program when somebody is succeeding there. So that's why I'm comfortable doing the suspension so that if you do what you're supposed to do, we're all clear.
There was a question, because there's another young man that goes to the DRC, and his probation allowed him, I don't know if it's the same circuit or not, but they gave him a piece of paper for every class that he takes, that they mark as a community service hour. Is that even feasible or possible?
I've never considered that, frankly, but I don't mind. I'll put it on the list of things to discuss internally. I'm not inherently against it, but I'm also not inherently for it either. I'll think about it.
I agree. I see what you're saying, because there's actually no work being done.
Right, because I don't want to create a double dipping scenario, but it's an idea worth considering, and we're all about really good, bad ideas. So,
Here we go.
Well, I'll certainly look into it. So, okay.
Thanks. Report next Wednesday, the 8th.
Next Wednesday, the 8th.
It's
All right.
on the paper.
Yeah, so if you'll step out in the hallway,
Y'all have a
sign
blessed
it out
day.
there, and then you're good to go. And thank you. All right, that's everything on the calendar. Let's talk with the walk-in, Mr. Shannon, who is in cuffs in the jury box, 22 SR 0913. Okay. I'm gonna place you under oath. You ready?
Yes, sir.
You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God, I swear.
All right. What's your full name, first, middle, last?
Yakari Gerard Shannon.
Mr. Shannon, what's your birth year? 1980?
Yes, sir.
Okay. And I have your middle name spelled two different ways. Spell your middle name for me.
Jerod.
Okay, just one R. All right, so, Mr. Shannon, you are currently in handcuffs, and you are walking in on 22 SR 0913. I'm going to put my history of my experience with you this morning on the record, and then you're welcome to do the same from your perspective. But my perspective is that you came in here to court, you sat on the second row back on my right, your left. And when I went over the PowerPoint, one of the things I asked was that folks not have sidebar conversations. You did speak to your person you were sitting with a couple of times. I let it pass. It was not loud enough to be disruptive. It was just loud enough for me to be aware. And they were very short conversations. Then what happened from my perspective is I'm up here trying to hold court, and suddenly you're talking so loudly that I can't hear the people that are talking to me up here. And when I look up, you're not facing your partner, you're facing me. And I don't have a clue what you were trying to say. And frankly, I don't care. So either you were talking very loudly to the person next to you while facing me, or you were trying to get information to me. But either way, I had to stop court and deal with it. What I had the option to do, and what I normally do at that point, is have a contempt hearing. And contempt can carry to 20 days in jail. I tried to extend a little bit of courtesy to you in my very frustrated moment and ask you to step out. You started to say something else. I ordered you to get up and leave my courtroom. When you did so, your pants were below your butt, and I could see your butt cheeks moving as you were walking out the door. I thought that was the second part that was completely inappropriate, and you said additional things as you were walking out. You may not remember that, and I may remember it wrong, but either way, I'm just trying to say that it's a drip, drip, drip of moments that frankly got me past my point of frankly caring. I specifically said, step out into the hallway. I specifically said it because I say it the same way every time. Step out into the hallway. When I sent them out to get you, you were gone. No one knows where you were, but you were certainly not in the hallway. And at that point, I said, forget it. He has a bench warrant. He is not here. I have not lifted the warrant. He has not entered the pretrial diversion program. Take him into custody when you see him, and I will go see him out at the jail. So I'm letting you know from my perspective how things have played out this morning. I would like to hear how things played out from your perspective this morning.
Okay, Your Honor. I was told I was never supposed to step in your courtroom today. I was supposed to meet my public defender outside on the courtroom step, signed some paper, went to the probation office, and that's supposed to have been it. What I said was to my girlfriend over there, which I said once, I think I need to go call my public defender, see what's going on, because I should not be sitting here. I got places to be, like eat lunch with my child, and that's over with. And now I'm in handcuffs. When it's all supposed to be just a sign of paper and going to the probation office, and that's what I've been on about my way to Ann Street School to eat lunch with my child. Now I'm sitting here in front of you in handcuffs.
The paperwork was signed. Your attorney and I spoke about it just to fill you in on your concerns. Your attorney was here early for court looking for you. Your attorney needed to leave. And so your attorney signed the paperwork, left it here. I think the solicitor's office had it. I saw it. And he needed to leave. I think he spoke with you before he left, I believe, and got you to sign everything up.
He told me to sit in the hallway. I was supposed to sit in the hallway and wait on the probation officer to come in the hallway. I said, no. He told me I ain't had to come in here. Why we're in here, I do not know.
Why did you come in here and sit down?
I guess the bailiff had the wrong guy there. He brought me here, and I told him I shouldn't be in here, but he made me come here anyway.
That's fine. Well, we can't leave you out there unsupervised. It's a secure hallway. Okay. Well, I understand what you're saying as far as you not having to be here. And to be fair, I didn't need to see you. What I needed you to do was sit quietly and wait for me to finish with Director Matthews so that she could finish your paperwork and get you signed out.
I understand, Your Honor.
But the fact is, though, is that you missed your jury trial.
And Your Honor, can I speak? Because, I have been through this before, and I had a couple of public defender lawyers, and I have never had a bench warrant with a public defender or a lawyer. Never in my history. They always get in touch with me and go over my pleas and ask me, do I want to accept a plea or something, and let me know what day I should be in the court. This time, that did not happen.
No one told you when to come to court?
No one told me, Your Honor. That happened in January. We are now in May. This matter should have been handled.
I agree with that. Let's see, I'm looking at the paperwork here. Let's see what I can find. Okay, is that your name?
Yes, sir.
All right, and that looks like the case we're dealing with here. Mr. Shannon so this thing is dated August 2nd, 23. Is that your signature right there?
Correct.
Okay, and are those your initials right there?
Correct.
And is that your handwriting there?
Correct.
And that's your address?
Correct.
And then coming up here, it says January 8th of 2024?
Correct.
All right, so you just said that you were not notified of your court date, and yet we just reviewed the document where not only were you notified, but you signed it and initialed it and filled out your application.
Yes, in August. I'm aware of
Let's not
that.
cut each other off.
I'm sorry,
It
Your Honor.
makes for not a good record. So now I'm going to ask you what you were about to say, which is help me understand how your testimony under oath is that you were not notified of the court dates, yet I have it here where you were.
Okay. August is how many months from January? There's a lot going on in my life, Your Honor. And the court did let me and my lawyer know they would not be notifying me, so my lawyer and I would have to be aware of our court date coming up in January. Which having a lawyer, if I was a lawyer, my client would never have a bench warrant. That's what I want to say, Your Honor.
Okay. All right. Well, Mr. Shannon, I'm more turned around now that we've had this conversation than I was, because you've provided me testimony under oath that nobody notified you of your court date.
At all.
And then I am the one who have pointed out to you that you were notified and that you actually received a copy, because it's a pull apart form where you get one and your attorney gets one and then the clerk gets the original, which means somebody somewhere handed you. See, this is where you cut me off again, and it's very frustrating, because I am giving you opportunities to speak, and I will continue giving you opportunities to speak, but you don't give me opportunities to speak. You keep cutting me off. So, and let me just say it real clear, Mr. Shannon, only one of us is going to run this courtroom in this hearing, and it is not going to be you. Is that clear?
Very clear, Your Honor.
Good. Don't interrupt me again.
Yes, sir.
And I will not interrupt you. I want to hear what you have to say, but I will not tolerate you interrupting me anymore.
Yes, sir.
I have printed a copy of this for you, Mr. Williams, if you'll give that to him. What I was trying to say, Mr. Shannon, is that you said a moment ago, under oath, that you were not notified of your court date until I reviewed that with you, and now you're saying that you were notified, but you forgot. I'm now more frustrated because we've had this huge interaction, and I didn't even get to the part where when you came back into this courtroom, you were wearing a hat. And I'm just like, of course you were wearing a hat when you came back into my courtroom. Like, of course that's what's happening. So you need to talk me out of just putting you in the jail and seeing you next Wednesday, because that is the solution in my book to this issue.
Your Honor, let's start over. I'm sorry for disrupting your courtroom this morning. My apology. But what I'm trying to say is, yes, I was notified in August, but I was a long way from January. So by me having a public defender, I was expecting my public defender at least in January, somewhere in January, to get me to come at least talk about my case. Because that's how it normally happens for me. But this time it did not happen, so here we go in May trying to resolve this case that should have been resolved in January. All I'm saying.
Okay. All right. I'm sorry, Mr. Shannon, but I'm not with you on this. I feel like this court goes above and beyond to make certain that our defendants know when their court dates are and knows what to do. So not only did you sign for it, but then you provided me with patently false information under oath, which is a felony, that you were not notified until I had to show you the document showing where you signed it. Up in Superior Court, they just mail you your notice and it's still valid service. We go above and beyond here. You came into court, you were continually talking to your person there. You were continually disrupting. I let it pass a couple of times until you got so loud that you weren't supposed to be there. I recognize that you thought you were not supposed to be in here, and that is technically true, but you were in here. You were here, and you had an obligation to conduct yourselves according to the rules of this court. You also were not appropriately clothed, and your private parts were visible, which is another issue. And then most important of all, When I asked you to step out into the hallway, you disappeared. I called your case again, you did not answer. The chaos that is surrounding your case, given the fact that you missed your jury trial after signing for it, tells me that I do not have your full attention. So here's what we're going to do. Piper, you're going to transport him. I'm executing the warrant. I'm placing you on next Wednesday's calendar. So next Wednesday, the paperwork will very likely come see you. It will very much look like probably what you have now, but that's not my decision to make.
Your Honor.
You see, there you are, interrupting me again, right in the middle of me trying to tell you what we're doing. I do want to hear from you, but again, I already told you, don't interrupt me again. You're going to go next Wednesday at 9 a.m. They're going to come see you. You will have an opportunity to try to resolve your case again. If that's the case, then you will get a chance to, if they're offering it still, you'll get a chance to do the pretrial intervention program. Okay, now I want to hear what you have to say.
Is there any kind of way I can just pay this off and be done with this today, Your Honor?
Well, that's what was on the table.
I have
I'm sorry, I
lot
cut
going
you
on.
off. That's
Sorry.
my bad.
I'm sorry, Your Honor.
No, that's on me.
For everything that happened today, I am sorry. Because this supposed to have been a great day for me. I supposed to came here, signed some paper, went on about my day. Now I'm in handcuffs, Your Honor. I know you're a great person. Just give me one more chance. I'm a great person also. I did go outside, Kyle was mad, to get some air smoke, smoke my vape, Your Honor. And you did tell me to go to the highway. I'm sorry for that. But I have a lot going on, sir. And 5 days in the county jail, I mean, it's not something I can really afford right now.
Sure. Ma'am, I strongly suggest you keep your audible size to yourself.
Understand me?
I strongly
I
suggest
apologize
that.
for her, sir.
I strongly suggest
Can
that
we
you
please
not make any
resolve
more
this?
noise, ma'am.
Can we please resolve this today,
Mr.
right now?
Shannon,
Please, Your Honor.
I need to put one more thing on the record. This is your 24th case in this court. And I have 00A5, possession of alcohol under 21, 0SR 11627. I have 00SR 2600, 00SR 432, 00SR 7538, 02SR 11908, 02SR 1713, 02SR 912, 03SR 6180, 04R, that one's a felony, 364, 03SR 6180, 04R 364, another felony, 06SR 1368, 06SR 1653, 08SR 6956, 10R, another felony, 641. Then we jump forward to 22 SR 913, this case, and then we jump backwards to 99 SR 4720, 99 SR 5388, and 99 SR 8185. So that's not quite 24, I counted that wrong, but it's over 20. So, Mr. Shannon, it's very clear to me that you have a long and distinguished history with this court. I don't have your attention, and I'm about to get it. So, Piper, you can take him. So, they will be out to see
I just
you.
want you to know I'm a changed man since all those cases. You can see how many years those cases have been. So you can see that I'm a changed man, Your Honor.
I was hoping that, but your interactions with me today do not
Okay.
show that. So, but hey, I'm not going to have this discussion with you anymore. We both heard everything we need to hear, and you need to quietly
Thank
go
you.
with Piper.
Thank you, Your Honor.
Thank you. All right, it's 10:54. Issue the warrants, forfeit the cash bonds. All I've done today is execute the warrant that was already stamped.